Welcome everybody to tonight's webcast of Meetings and Records, the Legal Requirements. I'm Ralph Troiano. I'll be your guide through the topic this evening. This is part of the C.I.A. Services seminar series that we've been conducting for 14 years now. The whole purpose of the seminar series is to provide valuable folks like you, the volunteers and the communities, with information that will make you more comfortable in your roles for your associations. It'll also help you, give you options in the decisions you need to make. This year, we're exploring a webcast format. Our whole goal of this is to make it more convenient for folks to attend our seminars. We've had thousands who have literally attended over the years, but not everyone can make it. So busy volunteers like you, our objective is to make it available from your home, from your office, from your smartphone, your tablet, your computer. Now, one of the things that has always been a really valuable part of our seminars is the interaction. And so I want to encourage you to ask questions throughout. Just type your information into the chat box. I'd like to introduce two people who are here assisting, and one of them is Kim Moore. She's one of our vice presidents, and she is the branch manager for our Southwest Houston office. She's sitting right in front of me and will be monitoring the comments that you enter into the chat box and then asking those questions aloud so that all of you can hear them for me to answer. In addition, we have Tina Jameson here. Tina Jameson is one of our executive vice presidents, and she oversees both our Bandera and our San Antonio office. Tina is behind the camera also in the production room, helping out with some of the technical aspects of this. So, we're mostly going to be talking about the Texas Property Code tonight. You may ask, well, if we're talking meetings and records, why aren't we talking about my particular bylaws and the rules of my community? Well, that's a great question. And that leads us into one concept I want to describe before we start. And that is the concept of precedence of documents. What that means is that if there is a conflict between different laws, ordinances, or your own community documents, what takes precedence? And it works this way. Federal law is right at the top. That takes precedence over state laws. State laws take precedence over local, county or city ordinances. And those ordinances take precedence over your local documents, your own bylaws, deed restrictions, articles, and all of those things. So when we're talking about the Texas Property Code, we really are talking about what applies to you. Now, there will be situations where state law has different words than your bylaws. I'm going to be pointing out those throughout the presentation. And where there is a difference between what state law says and what your documents say, the state law will prevail. So a large portion of what we're talking about tonight is the Texas Property Code, which absolutely does apply to you and your community. So let's go ahead and get started. Let's look at the agenda for this evening. We're going to be going through a number of things. The main topics, I'm going to give you some background on the legislature and how the Texas Property Code came to be what it is today and how it's evolved over time. And then the three main topics we'll talk about are association records, board meetings, and then elections and voting. At the very end, I'd like to give you a recap of what's happening so far in the current legislative session, which began in January of this year. So let's get started with some background. First off, the Texas legislature meets every 2 years, an odd number of years. We're currently in the 85th legislative session. The legislature meets for 140 days, starting in early January through the end of May. So session started this year on January 10th, I believe, and it ends on May 29th. There are a number of things in the property code which affect your association. We are private corporations. However, we are regulated by primarily by the Texas Property Code. This presentation is mostly about property owners associations, homeowners associations, community associations, community improvement associations, and all the other names. What it does not cover are condominiums, which have a slightly similar but slightly different set of laws, and commercial associations, which are partially covered by parts of the property code, but have a number of exceptions. So we're going to be concentrating on property owners associations. Everyone who's attending the seminar live tonight is from a property owners association. Now, the Texas Property Code is not that old. The first sections of the Property Code were only created in 1985. And all the early chapters of the Property Code provided help and solutions for associations. So, for example, some of the early chapters dealt with what do you do if your governing documents require 100% consent to amend them? That's not an easy thing to do. Or what if there was no provision in your document to renew, that it actually would expire someday? So the early chapters solved some of those problems and helped associations. And that changed in 2001. Leading up to 2001, there were a number of complaints to your elected representatives that indicated that a person's association maybe was not doing what was fair. Those complaints did not fall on deaf ears. The elected representatives decided to write some laws that would curtail the rights that associations previously had and give more transparency and freedom to the owners who live in those communities. That started with the passing of Chapter 209 in 2001. At the beginning of the 2001 session, there were some nice things that were put into the proposed laws. Nothing too significant, but it was going to provide some rights to homeowners. Legislators, the elected representatives, can file bills to about halfway through the session, 75 days into the session. And the bills were filed for 209, and then something happened. On April 10th, 2001, past the filing deadline, something happened that really rocked associations in a negative way in Texas, and that was an association on the north side of Houston foreclosed on a property that was owned free and clear by an 81-year-old widow. It hit the news when the constables were there shortly after that to evict her from the property and put her belongings on the street. It was a tragedy of errors what happened in that particular situation. In some of the other seminars, we go over the specifics of what was wrong with that situation. But for tonight, what was significant is there was a rush to amend those original bills. There were actually, I believe, 24 amendments that came up in the days after that foreclosure hit the news that put a lot of other restrictions on associations. In hindsight, what eventually passed was good. It created a fairness, a transparency that was well needed across all associations in Texas. So that was 2001. More things happened in the intervening years, but then in 2011, there was another change in what was being done in the property code. Starting in 2011, for the very first time, the legislature inserted a number of procedural issues that associations must follow. Much of what we'll be talking about tonight is about what happened in 2011 in the 82nd legislative session. In the next two, in 83rd and 84th, there were minor corrections and changes, nothing too significant in those sessions. And we're going to hear later on, in this session, as always, there are some really strange bills that are out there, but nothing that will be a sea change as we had in 2001 and then 2011. So, we are governed by the Texas Property Code, as I indicated. We are not governed by the Texas Open Meetings Act or the Texas Open Records Act, which you always hear those terms, but those apply to governmental entities. So cities and states and counties, school districts, taxing authorities, all of those are governed by open meetings and open records. Our Texas Property Code has provisions that are similar, but not exactly the same. So often when we're talking with homeowners who maybe serve on a school board or something like that, they have a slightly different understanding about what the requirements are, and we can help educate them as to what an association is under versus what a municipal entity is. At this point, I'd like to go over the first section, which is association records. So let's see what we're going to talk about. The first thing we're going to talk about is filing documents. We'll talk about access to records by owners. We'll talk about document retention and website posting. At the end of each of these sections, I've got some questions that have been posed in the past and that I'll be answering, what we call practical issues. And if you have any questions, absolutely put them in the chat box and Kim will ask me them. Let's start with filing documents. This is a very important one. What it indicates is this. Under the law, all dedicatory instruments must be filed in the public records. I'm going to define both of those in just a second. And this has been the law since 1999. Something has changed, but let's get to those definitions first. What are the public records? The public records mean you record it in the county in which your community sits. If your community straddles two counties, then you have to file it in both counties. What is a dedicatory instrument? That is the key issue. A dedicatory instrument is defined as any document that governs the creation, the operation, or the maintenance of the community association. And so the creation, that would be the articles of incorporation, the bylaws, the plats, the deed restrictions. Then operation and maintenance. Operation would be, for example, the collection procedures, the deed restriction enforcement procedures, the tennis court rules, the pool rules, how you get your tennis court keys. All of those things have to do with the operation and maintenance of the association. What changed in 2015 was very significant. Up until then, the law said you had to file these things, but if you didn't, oh well, there was no repercussion, no ramifications. In 2015, the law was changed to say, essentially, if a document is not filed in the public records, it doesn't exist. So if you're trying to use that document to ask owners to do something, to ask children not to run on the pool deck, if it's not filed under state law, it doesn't exist. So that is a very significant change. There are many rules that associations have out there, or there are rules, let me phrase it that way, that associations have that aren't necessarily one in writing or filed in the public records. This is a concern when you get into a litigation situation or a dispute situation or a situation where you're trying to fine for someone breaking a rule. And so you never want to be in a position where you're in violation of state law, clearly. We'll go ahead and be talking about a number of these things, but I want you to keep in the back of your mind that the law says all dedicatory instruments must be filed in the county, and if they're not filed, essentially they don't exist from a standpoint of being able to use them for enforcement or anything else. The next thing I want to get to is access to records. Almost all bylaws have some statement in there that indicates that owners or members of the association have a right to see the records. Sometimes it says the financial records of an association. Even if it's not in your bylaws, state law says that owners have a right to access the association's records. And effective January 1st, 2012, this came out of the 82nd legislative session, the law was written to say every association in the state must create and adopt a access to records policy. And specifically, it's described as a records production and copying policy. And it must be filed in the public records by January 1st, 2012. A couple specific things that are in that law that I want to point out is that previously a member had access to the records. Now a member can designate anyone they want to access the records for them. So a member could designate their friend, their neighbor, their accountant, their attorney, themselves. They can designate anyone they want who would be able to access the records. It doesn't have to be them and only them. The new law has a very nice thing, which is it allows an association to be flexible as to how it produces the records. Previously, an owner would need to come into the office if you had a management company, or go to the board member's house who was holding the records, and look at the records and then determine that they would like copies of those particular records, and they would get those copies after they paid for them. Now the law is a little more flexible. It allows an owner to designate that I would like to receive the records by email, I want to pick them up, I want to just view them. So there are multiple ways that we can produce the records for them to make it more convenient for them and also more convenient for the association. So if an owner simply wants to see, could I see the minutes from the January meeting, and the minutes have already been approved, we say sure, and we can just email them the minutes. They don't have to physically come to the office, go through the dance of looking at it, saying, yes, I do want a copy of this, and then we give it to them. So that's a very positive thing from the standpoint of an owner in the community. The law does put a procedure around all of this that is, has many steps to it for an owner to access the records. Normally, we're much more flexible with that. Again, if they just want a document, give us a phone call, send us an email, we'll send you the document. If they want to access all of the minutes from the last 10 years and 5 years worth of financials, we're going to ask them to be very specific about what they want, how they'd like it, and we'll estimate the cost in advance before providing it to them. So the law is good in the way it's written. It ensures that an owner can get access to records. A companion bill that passed at the same time in the 82nd session in 2011 was document retention. These two go together very nicely, because if an association in the past wanted to be difficult with owners and not be forthcoming about records, then an association could just destroy lose records that they didn't want to show people. That would certainly have been an abuse, and one of the reasons these laws are in place. So in terms of document retention, the Texas Property Code also said that you need to produce a second policy. The first one being the records production and copying policy, and a document retention policy. The law has, as is shown on this particular slide, the law has some minimum retention periods. And so you can see that books and records are, financial records are 7 years, and tax returns are 7 years, and contracts that are more than a year contract, you must keep them for 4 years after the contract expires. Those are the minimum requirements. If you look at any of our communities on the website, you'll see our standard document retention policy. And in that policy, we've expanded on this a little bit because there were some things that the legislature left out. For example, they don't require at all that an association keep records on home improvement applications, new home construction applications, other records of the ACC, variance requests, and things of that sort, which at C.I.A. Services, we feel those are important records that ought to be kept for a long time, if not permanently. The samples that you got prior to the seminar, which is a whole list right here, those samples have copies of document retention policies, records, production, and things of that sort. But you can also go onto our website and look at any of our communities, and you'll see those documents out there. The next topic that came up in that particular session was website posting. This one's a little bit interesting. Specifically, what the law says is that if the association or a management company on behalf of the association maintains a publicly accessible website, then all of the dedicatory instruments must be posted on it. That sounds simple enough. You might say, but wait, that's a duplication. They already said we needed to file it in the county public records. Why should we also have to file it on the website? Well, that's a good question, but it's pretty logical. If you've ever tried to search through the public records, they have literally millions of documents throughout Texas in the county public records. And so it's not real easy for you to find documents you might want to find. Whereas if I am interested in my community, then if we have a website, I should be able to find everything out there. So that's the purpose of this law. And in addition, someone who might be considering purchasing a property in your community, it would be nice if they could look in one place and find out what the rules are for the community. That's the purpose of the law. Fortunately for all of you who are using C.I.A. services, we keep those documents current on our website. At the bottom of the screen, you'll see a little bit of a graphic of what our community documents page looks like. Any person in the world, not just your owners, anybody can go out there and they can click and find the articles of incorporation, the deed restrictions, plats, architectural guidelines are all there for people to see. The next issue, or the next thing I want to go through are some practical issues of what we just talked about. So we covered everything from the need to file records in the public records, file documents in the public records, records accessed by owners. We talked about the need to retain documents and to post on the website. But here are some questions. Does an owner need a good reason to access the records? The short answer is no. An owner has an absolute right, for whatever reason they want to access the records. In the olden days, and I'm talking really about only before the 2011 session, an owner would we'd kind of say, so what do you want to see them for? Because that was the understanding that they had to have a reason to access the records. In truth, they could answer, I want to see them because. And we should have shown them the records, and we always did. But there were some cases where associations would say, well, you've got to have a reason for this or we're not going to show it to you. That never was the right thing to do, and the law has made it very clear, no need to have a good reason or any reason. Owners have a right to see the records of the association. Next question is, are records of individual owners available for inspection? Well, again, the legislature did this right, and they indicated that certain things are private. So records of a particular owner are not available for other owners to see. There could be lots of things in there. There could be information about a bankruptcy. They could have written a letter to the board indicating that they're having financial issues or medical issues that was privately conveyed to the board. It could have copies of checks in there, so their checking account information is on there. So the law is clear that records of an individual owner are not available to anyone else unless that owner specifically gives written permission for another owner to look at them. Another thing which is protected and not available in the access to records policy are attorney-client communications. So anything from the attorney regarding the status of collection, status of deed restrictions, other attorney opinions, or anything of that sort is not subject to inspection and access by the members. A question that comes up often is whether or not meeting minutes are available for inspection before the board of directors approves them. And the answer is no. They're still a work in progress and could have errors in them. They are going to be reviewed by the board of directors, the folks who were at the prior meeting, and once the board of directors approves them, then they are available for inspection. But until then, they're simply a draft and a work paper for the association. Later on, when we talk about meeting minutes or minutes of meetings, often a question comes up about should we post these on the website? Our answer almost always is no. Remember, these minutes are available to the whole world. On our website, there's no password to get behind the door to actually look at them. Anyone could see them. So we'll be describing a way that we believe is better than posting the minutes on your website, and that is to post a summary. A summary can go up there the night of the meeting, the day after the meeting, whereas meeting minutes, if you're only meeting quarterly, it'll be 3 months before they could be posted. So we'll go over that later also. Next question is, do pool rules need to be filed in the county public records? We answered that a little bit earlier. The law says that all dedicatory instruments must be filed in the public records or they don't exist. A dedicatory instrument is something that guides the operation of the association. Is a pool rule one of the things that guides the operation of the association? Yes, it is. And so the answer is, yep, pool rules do need to be filed in the public records. The last question I wanted to go over here is, if records are not destroyed after the expiration date, if you will, of the document retention policy, would they still need to be made available for inspection? Let me go into that a little bit more detail. You might think that it's easy to destroy records after 4 years, 6 years, 7 years, whatever your document retention policy says. Well, if there are paper records, it never was easy because they've probably been archived into a box. They're sitting in a dusty, hot storage area, and there may be mixed information in there. You may have things in that single box that have permanent retention, 7-year retention, 4-year retention, 4-year after the expiration of the contract expiration. And so it's hard to go through all those boxes every year and determine what should be removed. In addition, you're not going through it every day. If a contract expires in February, another one in June, well, under the document retention policy, you'd have to go at the end of February and at the end of June, 4 years later, and pull those out to destroy them. And even with electronic records, it's still not easy to destroy all parts of those records. So, with that said, there hasn't, that I'm aware of, been any case law yet to say the answer to this question. If a document still exists, but under the policy, it could have been destroyed, would you need to produce that record? To answer that, if you look at all of the document retention policies that C.I.A. Services propose to our clients, what you'll find is there's a statement in there that basically says, if a document has not yet been destroyed, which is beyond its retention period, that document is considered to no longer be available and to be no longer an association record. So we put that statement in there. Would that ever be challenged if we were asked to produce something that truly still exists but is beyond the retention period? Possibly. We don't know. The next section we're going to go through is board meetings. There are several topics in here, and this is a section that affects all of you. Every time you're in a board meeting or preparing for a board meeting, these topics apply to you. The first one is notice to members. Tied to that is open meetings, the new obligation starting in 2012 that associations notify their members of meetings and welcome them to come to meetings, to board meetings. We'll talk about executive sessions where you can ask those people who came to the meeting to please step out while we talk about certain sensitive topics. We'll talk about the ability to actually hold a meeting which is not announced. There are certain times that we need to conduct business. Either we did not have time to announce the meeting because it's urgent, or because this was a topic that under law doesn't need to be held in an announced board meeting. We'll touch on the meeting minutes, as I mentioned earlier, and then we'll go into practical issues. So with that, let's go ahead and start with our notices to members. All members must receive an announcement of a board meeting that is going to be held. And that notice must provide the date, time, place, and general topics that will be discussed at that particular meeting. The law defines a board meeting a little bit differently than you may consider it. So it's important to understand what the law says a board meeting is. A board meeting is where you have a quorum of board members, that makes sense, where action is taken. That last part is a little bit different. You may go to a board meeting, you may conduct discussions and other things without actually taking action. So for example, if the board is getting together for a workshop, let's say you want to get together and hash over the budget and get all the details worked out, but you're not going to approve the budget, you're just going to do a board workshop on the budget. Under the law, you have a quorum, but you're not going to take any action. So a workshop of that sort would not need to be announced to the members. If the board was going to get together, for example, and meet with a pool contractor in April before the season starts, and get the lifeguards there, talk to the pool company about the expectations for the summer. You're not going to make any decisions. You do have a quorum. It's not a board meeting that would require an announcement to the members. So that notice to the members, how does it get to them? What are the requirements under the law? The law provides two options for a board. The first one is you can mail a notice of that meeting to everybody in the association 10 to 60 days in advance. For most board meetings, that doesn't work out too well because, one, you may not have your agenda 10 days in advance, certainly not 60 days in advance. And if you have to mail it to everyone, if you have 500 homeowners, that's $500 worth of postage and mailing cost and reproduction costs. So typically, that is not how it's done. How we do it here at C.I.A. Services for all of your board meetings is the second one that's listed there. On the second one, you must post in advance, 72 hours in advance, 3 days before the meeting starts. You must post the notice with date, time, place, and general topics. That can either be posted on a website, which is what we do, and I'll show you that in a moment, or in a conspicuous place in the neighborhood. That's kind of interesting because you could post it, for example, on the board president's front door. Not that you'd want to, but you could. Would people know to go to the board member's front door to see it? No, they wouldn't. But the law does allow that. What we do is we post it on the website. If you take approach number 2, there's 2 things you must do. Post it on a website and email everyone who has registered their request to receive these notices. You must email them the date, time, place, and the general topics. We do both of those. So all of you see each month something posted on the website. You also see an e-blast that you receive from the community manager or the assistant that has the attached to it the agenda for the meeting. So that's how we send things out to folks. Later on under practical issues, I'll talk about that whole email concept, doing the e-blast, and what the obligations of the association are versus the obligations of a particular homeowner. On the next page, you can see a picture of what is posted on our website. So the top portion there indicates that there will be a meeting at this date, time, and place. If you click the link at the bottom, you'll see the actual agenda for the meeting. We found that posting the agenda makes sure that all the expected topics are shown and get to the homeowner. The law doesn't require you send the agenda. You could just say, have a statement that says we're going to talk about minutes, financial reports, compliance issues, old and new business, and we won't have an executive session. So you could just have that sentence I just said, and that would comply with the law. We feel sending the agenda out provides more information for the owner so they can decide whether or not they would like to attend the meeting. If you look at what's up on the screen there, you'll see that we send a meeting e-blast. The e-blast basically says, hey, we're going to have a meeting. This particular one indicates an agenda is attached, and also goes into a few words about, at the beginning of the meeting, we have an open forum where any owner can speak and bring up their concerns or questions to the board of directors. That's going to get into my next section, but we're giving them advance notice that you're encouraged and welcome to attend. Just come to the meeting and we have time at the beginning for you. Well, let's now go into, now that we've told everyone we're having this meeting, and you know just dozens of people are going to want to flock to that meeting, let's go ahead and talk about what an open meeting is all about. The law says that all board meetings are open to members. Members are the owners, the people who own property in the community. The law is about owners and members. It's not about residents It's a minor distinction, but I suppose if you chose to, you could say, oh, you're a tenant, you can't come in. Please don't make that distinction. If someone lives in the community, you want to encourage them to be a part of the community, and that's how tenants are good neighbors as opposed to problematic if you make them feel welcome in the community. So if someone wants to come to the meeting, they are welcome to be there. Now, the purpose of this law is so that people can see what the board's doing. It's not a members' meeting, it's a board meeting. So the law allows them to come and look. There is nothing in the law that gives an owner a right to participate in the meeting. With that said, if someone comes to the meeting, and I was sarcastic before when I said dozens of people are coming to most meetings, generally it's the board of directors and the manager. But if someone comes to the meeting, you want to welcome them. You want to know why they're there. What is that concerns them? What are their suggestions? What can we do for you? And so, although they don't have a right to speak, you want to give time. Typically at the beginning of the meeting, you set aside 5, 10, 15, 20 minutes, depending on the size of your community and the participation, where each owner who comes, you want to address each person. Thank you for coming. What would you like to say? Where each person has an opportunity to speak to the board. Now you do want to have rules. In the e-blast you just saw, it put those rules right up front. It says we have time, you have 3 minutes to speak, and things of that sort. If you don't put it in the e-blast, that's just fine. When you welcome them to the meeting, simply state the presiding officer would thank them for coming. We really appreciate your participation. We've got about 10 minutes at the beginning of the meeting, and I'd like to go around and find out what each of you would like to address to the board. And so right there, in a very friendly way, you provide what they should anticipate. You don't say you've got 30 minutes each to speak. Also, if someone brings up something that's not on the agenda, something that you don't know the answer to, the board should never feel pressured into giving an answer. If someone asks a question that has legal implications, or if someone asks a question that would require your community manager to go back to the office and look things up in the records, don't feel obligated to give them an on-the-spot answer if they have a question, but indicate that thank you, we're going to write this down as follow-up, we'll give it to you next month, the community manager will send you an email tomorrow, whatever it is. Again, we want to welcome people who do come to the meeting. Now, with that said, and this whole slide is labeled open meetings, fortunately the law, just like in governmental entities, the law does allow executive sessions. Executive sessions are where we can actually ask the residents who have come to leave the meeting. But the law is very specific. We can't just tell people to get out because we don't want them to hear the financial report, or we don't want them to hear about any particular topic. The law is very specific, and it talks about the things where we can exclude owners from being at the meeting. Before this law passed, at C.I.A. Services and in many, many management companies, we had an innate sense of what was an executive session item. And I want to list these, and then I've got a question I want to go to, but they're very logical. And so if it involves personnel, let's say an association actually has employees, and we have an issue with one of our employees, a personnel issue, that's something that would be done in executive session. If we have litigation or pending litigation, and Donna earlier had asked the question about a pending litigation issue, that's an area where we can exclude residents. Contract negotiations. If we've got a couple bids in front of us, and we want to bring a contractor in and say, you know, we want you to go a little bit lower, or whatever the negotiations might be, we can do that in executive session so the competitors can eventually read our meeting minutes or understand what the bids were. Enforcement action. So if we're about to file a lawsuit, if we're going to fine a homeowner for a particular issue, if we're going to kick someone out of the pool for acting badly, those are enforcement actions. Attorney-client issues, private matters. So if we're going to talk about a particular homeowner, maybe they have a late fee on their account, maybe they want an extended payment plan, and they're telling us, they're pouring their heart out about health issues or financial issues, that absolutely does not need to be done in public. And the last one is, if any owner specifically says, I'd like to talk to the board, I really want to do it in private. Maybe they want to complain about one of their neighbors, but they don't want their neighbor to know. So if anyone requests privacy, that's a legitimate reason to go into executive session. The only people in the executive session are the board members and anyone else appropriate, the attorney, the community manager, the parties involved, and things like that. So Kim, do you have a question that I might be able to answer?
Yes, Ralph. I have a question coming from Cynthia Velez. She would like to know, when we send out the e-blast notifying of the agenda for the meeting, it says, if you want to get on the agenda, please let us know 10 days in advance. How does that happen if we're sending out the email 72 hours in advance of the meeting?
Yeah, oh, excellent question. Wow. It's a math question too, because what we have here is the law says 72 hours in advance, which is 3 days, but we're saying we want 10 days notice for getting something specifically put on the agenda. And there's rationale behind that. The board package and the agenda is actually put out and prepared in advance so that the board members receive information many days in advance. And so if someone wants to be on this specific agenda, then we need to do all that preparation in advance. So when you get the notice that a meeting's about to occur, the package is already put together, the agenda has already been set. So the approach you take is, if you want to be on the agenda, don't wait till you get the notice. Whenever you feel like you want to speak to the board, get that information to the community manager, and whenever the next meeting is, you'll be on the agenda. And that meeting could be 2 months from now if a community only meets quarterly. So I hope that answers it. How about another question on open meetings and agendas?
Ralph, Carlos Hernandez would like to know, are board members allowed to choose their own contractors and agree as a board to pursue a project such as choosing their landscaping company to enhance their community?
Well, that's a very interesting question from San Antonio. Hey, Carlos. It doesn't have to do with open meetings, but it does have to do with decision making. So let me briefly touch on that. And there's actually a law that deals with this also that came in 2015. So thanks for that prompt, because that'll get me to talk about another topic. So can a board member, an individual board member, choose a contractor? Individual board members have zero authority. All of your governing documents talk about the board making decisions. They don't give an officer, such as the president, the vice president, secretary, treasurer, authority to make decisions independent of the board. Now, there are some cases where an association may adopt a policy on authority that, for example, might give an individual board member the authority to spend up to $100 without getting a vote of the rest of the board members. That's different. So does an individual board member have the authority to enter into a contract? The answer is no. When going out for bids, it's always welcome to receive potential contractors that should bid on this. And individual board members have a lot of experience. If we're talking about someone who can fix an air conditioning system in a clubhouse, well, darn, probably every board member has had an air conditioner fixed in their home and has had a positive or negative experience. So absolutely input is needed However, individual board members do not have that authority. Let me just touch very briefly on the issue that was passed in the last legislative session in 2015, and that has to do with disclosure. There have been concerns about a board member having a financial or other interest in a contractor for the association. So for example, if a board member has a grounds maintenance company, and we actually have this situation in one community that I'm aware of, a board member has a nice sized grounds maintenance company. The community that that board member is in, and that board member's had the company for decades, has lived in the community for slightly less than that amount of time, and that company has always been doing the grounds maintenance in that community. They do a wonderful job. They do it at a price which is way below market. Under the law, in that situation, that board member must disclose to all the other board members, if it weren't already known. In this case, it was well known, and it was disclosed to the other board members, I own this company. I own this grounds maintenance company. So disclosure is required under the law. Secondly, that board member may not participate in the discussion or the vote that would involve hiring or not hiring that one. Even if they don't want to hire that one, they can't vote to that board member who's involved can't participate in the vote, even to vote for someone else. So those are the two things on disclosure. And so Carlos, thanks for the whole question on choosing contractors and individual board members' authority. Let's finish up on the executive session. And an executive session is part of a board meeting. It's not a separate meeting. It used to always, I used to always find it funny in a lot of times when I talk about the early days. I'm so old, it's 30 years ago when we started the company. But in the old days, I used to find a lot of management companies would keep two sets of minutes. One for the board meeting and a totally separate set of meeting minutes for the executive session. And in their office, they would put the regular minutes in one filing cabinet, maybe one drawer of a filing cabinet or one folder, and the executive in another. And they felt that by doing that, they were able to, if someone wanted to examine the records, they'd say, oh, here's the open ones. We're not going to show you what's behind the door here. That was never true. The law has always said records are records. If someone asks to see the records, they see them. And so now the laws that have come in have helped clarify that. And nobody keeps two sets of records minutes anymore that I'm aware of. It's just not the way to do things. So the next slide is simply an illustration of this. You call a meeting to order, you go into executive session, you do all your deliberation, you make your decisions in executive session. You then come out of executive session, ask everyone to come back in the room, all those folks who are there, come back in the room, and you must, under the law, summarize what you discussed in executive session and what decisions were made in executive session. And you do it generically. You do not compromise the confidentiality of whatever was said there. So, for example, if you go into executive session and you talk about a particular homeowner who's delinquent on their dues, and you go into all the communications that have occurred and all the letters that have been sent, and you vote to file a lawsuit for uncollected assessments, when you come out of executive session, invite everyone back in, you state, in executive session, the board of directors discussed collection issues and made a decision to file a lawsuit against one homeowner. Done. So owners who are at that meeting get a sense of what was done in executive session, but you not at all have compromised what was there. So what's in the meeting minutes? The meeting minutes is almost exactly what you said. There will be a motion that is written into the meeting minutes that says the board of directors agreed to file a lawsuit on one account. Typically, we will refer to, in the case of collections, a line number on that report that you have in your board package. A line number is just a line number. It's not an account number. Sometimes we'll use an account number. If it's a deed restriction issue, we will refer to the violation reference number that people wouldn't be able to associate with a particular property. Let's go on to the next topic. We said that board meetings are open. Kind of. And that's another really good thing about the way this law was crafted. The law allows what we at C.I.A. Services refers to as an unannounced meeting. Those aren't the words in the law, but that gives you a better sense about how the law is crafted. The law does allow you to hold a meeting that you don't tell anyone about. It's an unannounced meeting. The law is very specific about what you cannot do in an unannounced meeting. It doesn't say what you can do, it says what you cannot do. The reason it goes into what you cannot do is it's basically saying things on this list that I'm about to go over, you must do at an open, announced meeting. So, I'm going to go over those topics in a second, but I'd like to expand on what an unannounced meeting can be. We all think about a board meeting, an open board meeting, you all go into a room, you sit there and people can walk in the door. On an unannounced meeting, you have many additional options. You can, under the law, you can meet using any mode of communication that you choose. So that mode of communication could be in person, you're sitting across from someone. It could be on the phone, and then the law says various electronic means, which can be online meetings, a webcast like this. What the law does require, though, is whatever method that you use for meeting, each board member must have the ability to see and hear, or to hear and be heard. The law has been clarified that hear and be heard can actually be words. That's what brings in the ability to have an unannounced meeting that is an email vote. Everyone has an opportunity to read my email that I send out to the other board members. If I'm a board member, or if I'm the manager, I send it out to all the board members that says, hey guys, I'd like you to vote on this. Everyone gets to see and hear, or in this case, read what I have produced. Everyone gets to hit the reply all button to say what they want to everyone, and everyone gets to vote. So that's why an email vote is a form of an unannounced meeting that is allowed under the law. We didn't have to tell the whole world, or specifically all of the owners in the community, that we're going to have this email conversation or an email vote because it's an unannounced meeting. So, I want to, and there's a few more words on that slide, but I want to get to what we cannot do in an unannounced meeting. And all of these make a whole lot of sense. The first one, we can't adopt or amend dedicatory instruments. So if we want to amend our bylaws, because the board has a right to do it, we want the owners to be able to see what we're doing and not necessarily participate in the meeting, but they could see what our logic is and our thought process is for amending the bylaws. Let's go a little bit further. A dedicatory instrument includes pool rules. Yep, if you want to change your pool rules to say that now you can chew gum in the pool, or whatever you might want to change it to, that is something that would need to be in an announced meeting. That's what the law says. You cannot appoint officers in an unannounced meeting. So if you are going to have your meeting right after the annual meeting where you decide among yourselves who's going to be president, vice president, secretary, and treasurer, that must be an announced meeting. It used to be that particular one right there. that you'd have your annual meeting, and then once everyone clears out of the cafeteria at the school, the 5 board members would just stand up together and said, okay, who wants to be president? They'd take a vote right there, and you'd be done with it. Now, when a community wants to do that, we simultaneously send out the annual meeting announcement, and it will immediately follow with a board meeting to appoint officers. So that must be there. Filling a vacancy on the board. If someone resigns and you want to appoint someone into that position, it must be in a called meeting where you notice it to the owners. The next 4 are all very curious. I'll explain them and you say, yeah, that makes sense. But it'll be curious when I tell you why. If you're going to initiate a foreclosure action, that must be in a called meeting. If you're going to do fines or putting something on someone's account because they damage property, if you're going to initiate compliance issues, so deed restriction enforcement, or if you're going to do in appeal, someone wants to appeal a decision of the ACC. All of those must be in announced meetings. Why am I saying it's curious? Because every one of those are things that you would do in an executive session of an announced meeting, which means, sure, you tell everyone you're going to do this, but you tell them to leave the room when you do it. So that's why all of those are a little bit curious. If we move on to the next slide, there's a few more. Suspension of rights of an owner, so you want to kick a child out of the pool for a week. You must do that in an announced meeting, but again, in executive session. The next 2 are important. You must, under the law, do your budget approval in an announced meeting. What's curious is only if you're going to raise the assessment by 10% or more. Or I'm sorry, not raise the assessment, if you're going to increase your total budget, your total expense by 10% or more. At C.I.A. Services, we strongly believe you should not test that limit, that any time you're approving the budget for the association, you should announce it, do it in an open meeting, and then you don't have questions about people saying, well, you went up 9%, and so you hid it from us. No, approval of budgets, do it in an open meeting. If you're going to, similarly, if you're going to be increasing your assessment or levying a special assessment, open meetings. If you're going to approve capital projects, we're not talking replacement projects, we're not talking about regular maintenance. You must do it in an open meeting. For those of you who have not yet attended our super budget seminar, our super budgets, a replacement budget, a replacement expenditure is taking care of your existing assets. You have a tennis court and you're going to replace the windscreens. That is something that is a replacement one and could be done in an unannounced meeting. A capital project is putting in something new. So we're going to put in a brand new shade cover over a playground or something of that sort. Must be in an announced meeting. Last 2, if you're going to borrow money from a bank, if you're going to lend money to somebody, that's never a particularly good idea, but if you're going to borrow money or if you're going to buy or sell real estate, those all must be in an announced meeting. So, if we had any more questions, I could answer them, but at this point, I'm going to go on to meeting minutes. But before I do that, Kim, do we have a question?
Yes, Ralph, I have a question coming from Cynthia Velez. She'd like to know how soon before or after filing amendments to dedicatory instruments do the homeowners need to be advised?
Oh, nice question. I'm proud of our San Antonio folks who are asking these questions. Thank you, Cynthia. Great question. Let's talk about 2 aspects. When a dedicatory instrument becomes effective and the notification part of it. Under the law, the day the document is filed, the stamp date on that document is when it becomes effective. So if you have a change to a guideline, it's not when the board adopts it, it's not when a committee drafts it, it's when it actually gets notarized, signed, and recorded in the county that you're filing it in. So that's when it becomes effective under the law. The next question is very interesting about when do homeowners get to know about this? I'm going to give a couple answers. One is dedicatory instruments, any changes, adoptions, or amendment to them, as you just heard, must be adopted in an open meeting. And so owners would have known in advance that something's up, that we're going to talk about a bylaws amendment or a new guideline. And so that anyone who is getting the notices or looking at them will know that something's happening. After it's filed and becomes effective, there's no obligation under the law that we then send something out to the owners. The fact that it's filed in the public records is what's called constructive notice. Now, nobody goes out to the public records to see if something new is out there, but under the law, as soon as it's filed, that's all the required notice. Let's go to practice, though. In practice, we want to make sure that owners that are going to be affected by whatever we've just done know about it. And so there's many ways to do that. If it's a change in the pool rules, heck, you just put a new sign up. Or if it's long enough before the season, when they're registering for pool tags or pool keys or anything, you just make sure you are always giving them a copy of the current rules when they pick up their tags. If it is something relating to maybe a deed restriction issue, a new guideline or something of that sort, then I have one community right now who adopted a 9, 10, 11-page deed restriction procedure. It's a really great document, and what they've decided they're going to do, it's going to happen next month, is they're going to mail that full document to every single owner. That's a little bit more expensive than going the other alternative, but it gets it into everyone's hands. In between, it's absolutely going to be posted on the website. Maybe you send out a specific e-blast that either points them to the website or attaches that document to what you blast to them. That's really the way of the future, these push notices where we put it in their hands instead of expecting them to go find it. And so we are very much trying to, at C.I.A. Services, get as many email addresses as we can. We've got a really great system for distributing information, and in most communities we have maybe 50 to 75% of the email addresses. So we're not covering everyone, but we're trying to get to that point. What's another great question? What's another one?
Ralph, we have a question coming from Rudy Alafa out at Highland Meadows in Houston. Rudy would like to know, can a person be removed for disrupting the meeting legally? And how much time does a homeowner have to speak during the executive session?
Wonderful questions. Hi, Rudy. Good to hear from you. So there's two parts to that question. Can someone be removed who's disruptive? And I'm not exactly sure if we're talking about a disruptive resident who comes to the meeting or a disruptive board member who comes to the meeting. There's actually different approaches to those two. Keep in mind, if this is a board meeting, it is a board meeting. It is a right for someone to attend. It is not a right for someone to be disruptive or even to speak. So the privilege to speak is what's granted by the board of directors. We, of course, always want to be kind to our neighbors who have taken the time to come to the meeting. We want to be courteous to them. But we also want to be clear on whatever the rules are. That's why it's best to, at the beginning of that open session, to lay out the rules for the people who may not have read it in the e-blast, may have never come to a board meeting. And we would want to make sure we say, great, welcome for coming. We've got 5 minutes, we're on a tight agenda, we've got 10 minutes, whatever it might be. So I'd like to have time for all 3 of you who are here. So if we've got 10 minutes, that gives you about 3 minutes apiece. So what would you like to say? So you set the rules in advance and then gently enforce the rules. If it goes over a little bit, no problem. So that was one of the questions. And the other one was relating to, Kim, what was it relating to? A disruptive owner.
We've got the disruptive owner in a meeting. Rudy would also like to know how much time does a homeowner have to speak during an executive session?
The answer is that the board of directors sets the duration of an executive session. You always want to set an expectation. And so, for example, when an owner asks to have an executive session to meet privately with the board of directors, typically it might be disputing a deed restriction issue and our ACC issue. Our community managers send them in writing either a letter or an email that says, okay, we've set the date for this date, this place, this time. The executive session will be at the beginning of the meeting. We have set aside 20 minutes, 30 minutes, 15 minutes, whatever it is, for the executive session so that they already know coming in. In addition, what we'll do is we always want to tell that owner, by the way, you've sent us emails before. We have given the board of directors all of your information to read in advance. So you don't have to spend your time reiterating that, and so make good use of the time. So we want to always set expectations, but it's up to the board to set the duration of that executive session. How about one more? Thank you, Rudy.
All right, Ralph, I have a question coming from Norm out at Oakcrest. If a board member has used a contractor personally, must they abstain from a vote for the contractor if the board is considering using that contractor?
Great question. Oakcrest in San Antonio, gated community with 3 totally independent parts of the community, sets of gates. The board members are even from the different sections. It's a cool place, and Norm and the other board members are actually sitting in our San Antonio conference room enjoying some Mardi Gras food, I believe, is what they're having. So the question is, if a board member personally uses a contractor, can they participate in that vote? Absolutely. The only requirement under the law is that if you have a personal interest in that company, you can't be part of that vote and you must disclose it. So many times board members will have a good experience with a particular contractor and suggest that they be allowed to vote. So no problem at all with that. However, let me just point out, and I'm not talking specifically about Oakcrest, but in other places, believe me, if you as a board member make a strong recommendation and a pitch for a contractor, you better hope things go well with that contractor, or you'll get a lot of feedback from your fellow board members. Well, let's go ahead and on this particular slide we talk about meeting minutes. It should be no surprise that you should take meeting minutes. But the state legislature decided they needed to pass a motion to take pass a law that says you must take meeting minutes. That's because many times there were abuses with associations where they wouldn't keep meeting minutes. So when an owner wanted to examine the records of the association, there were none to examine. So that's why the law was passed. Just as a quick aside, there's a wide difference in opinion from anyone involved with meetings as to how detailed minutes should be. So the law actually addresses this, and it is the practice that certainly attorneys recommend, and it's a good practice. The purpose of the meeting minutes is to document the actions of the Board of Directors, the decisions of the Board of Directors. It's not to record for posterity the opinions of individual board members regarding issues. It's not there to document all sorts of things like that. I state here that they're called minutes and not hours. I mean, that's literally true. The purpose is to document the actions and not be a transcript of what occurred at the meeting. Now, once the minutes are approved, as we talked about earlier, then they're available for owner access. Until they're approved, we do not, it's a work document. It may be inaccurate. We may have information in there with typos or the wrong person attributed to who made the motion. So only once they're approved are they accessible to the members. There's also no obligation that we send these minutes to the members. Some associations like to do that, and I applaud them for the sentiment. However, if you're mailing them, that's expensive. If you're emailing them, it doesn't get to everybody. And there's a delay no matter how you do it. And so if you want to get the information out, what we really recommend is that you post summaries of the minutes on our website. So your community website administrator, who we train to access and modify your part of the website, would be able to create a summary. And the next slide has a really nice summary on it for one particular community. Those minutes, those particular minutes, were 3 pages of typed minutes. Here, it's very compact. It's easy for someone to read. They know what happened at the meeting. And so we see that, for example, that they approved some landscaping at one of the entries, that the purchase of some land finally went through that they were doing, and that they received a proposal from a company that they accepted to do some cleaning out of culverts. So right there, in 15 seconds, I summarized a 2.5-hour meeting. Someone is more likely to read this than they are the full minutes. And if you post it on the website, in this particular community, they would keep 6 months worth of summaries out there. And so you'd have, half a year's worth of activity of the Board of Directors. Let's just touch on a couple of practical issues. We had talked about notification, that we post it on the website 72 hours in advance, and we send out a e-blast to everyone that we have an email address for. So who's required to receive an email notice? There's a little bit of a maybe a different interpretation of what that means. The law says that we must send it to anyone who has registered their email address for this purpose. There are some attorneys who believe that a person doesn't need to register it, but if we have their email address, we must send it to them. So we've taken the more conservative approach, and that is, if we have an email address for you, you are going to get a copy of the meeting announcement. At the bottom of every one of our e-blasts, it says, if you don't want to get this, just tell us. So the default is we will send it to you, and if you don't want it, you just reply to opt out. So we send it to everyone. But what if an owner's email address changes? The law places the obligation on the owner to keep their email address, their mailing address, and all those things current with the association. So if we get a bounced email that says this address is no longer a valid Yahoo address, we immediately delete that email. So we've got a nice clean email list, but we don't go searching the internet to see if they've got some account with AT&T now or something. If they give us a new address, that's wonderful. Must all items be discussed be listed on the meeting notice? No. If you happen to have ever served on a municipal board of directors, a taxing entity, a mud district, a levee district, a school board, or anything like that, the laws for those entities are different. They're governed by the Texas Open Meetings Act. We're not. We're the Texas Property Code. For those meetings, if you're going to make a decision, it must be explicitly listed on the agenda. That doesn't apply to associations at this time. What if the notice is not posted 72 hours in advance? I told you that's what the law says. That shouldn't happen. That's our responsibility to make sure that it occurs. But let's say it doesn't happen and you're going to have this meeting. Well, you can continue to conduct it as long as you do only things that are allowed in an unannounced meeting. The alternative is to postpone the meeting, to repost, and things of that sort. But typically you'll want to hold the meeting, do the things you can, and then do the things you're not able to with proper posting. You don't want to slip by. The law says you need to do it this way, and that's what we need to do. Is an email vote an unannounced meeting? Well, if you were listening a while ago, I said yes, it is. Can we hold an online meeting or conference call meeting that is open to owners? Great question. Thank you, Kim. That's really interesting. Many of you travel, and we have some of our communities that only meet via a conference call or an online meeting. And so how do those communities deal with the fact that they must do at least a couple times a year a meeting that's announced to the owners? So when they're going to adopt the budget, that's got to be open to the owners. How do they do it? Well, we can have a conference call where we can let people know in that e-blast, if you are interested in attending, here is the conference call number, and allow them to call in. If it's an online meeting, if you're interested in attending, here is the link. I have one community, it's a commercial association, that does its annual meetings, or a couple commercial associations do their annual meetings as online meetings. That works out wonderfully because someone who's a commercial owner can be at their desk attending this annual meeting. And so, yes, we can. The only tricky part is you want to be able to get into an executive session if you need to, and make sure that the people who have joined in are not participating. Some of us aren't too good about hitting mute buttons and being able to exclude someone, so that's the only tricky part. You need to make sure you have your technical skills up to date to do an online meeting with an embedded executive session. Kim, do you have another question?
Yes, Rob, we have a great question this evening from Tony Arnone out at Aviara. He wants to know, how soon after a meeting should approved minutes be available to owners?
Excellent. Let me give a plug for Aviara and Tony. If in San Antonio, if you go to our last eNews Monthly, there's a clip in there to a really cool video. They did a wonderful project, landscaping project in the community, not a little one, a big landscaping project that had, it was like 40 tons, I believe, of rock that they put down and other landscaping. He put it to music with a Bob Seger song, Like a Rock. It's a great video. You can, if you go to eNews Monthly, you can click on that. Well worth seeing. So kudos to you. But his question was regarding meeting minutes. How soon after the meeting should they be available to members? As soon as they are adopted, they are official records of the association and are available to members. The question is on the distribution. And as I indicated earlier, there are many ways to distribute them. It could be an e-blast the day after saying, hey, we had a great meeting, here is a summary, or here are the minutes. Or an e-blast saying, we've just posted the new minutes out on the website, or a new summary on the website, go look at them. So literally, as soon as the motion passes to approve them, they are finalized as minutes and available. Let's look at the last couple items on here. Under practical issues, does a DR hearing, so an owner wants to talk to the board about the violation letters we sent, does a DR hearing need to be announced if that's all we're going to do? You know, we're not going to have a board meeting where we discuss other things, we're just going to have this hearing. And the answer is yes. The law doesn't differentiate. So that one is a real interesting one because you literally, you call the meeting to order, go into executive session, come out of executive session and adjourn the meeting. The only ones who will be participating in that meeting are the board and the homeowner and the manager. So if anyone comes to the meeting because we sent them an e-blast saying we're having the meeting, we welcome them in, tell them to leave, and we have our DR hearing. So that's what the law requires, and so it is a little unusual. Next one, does a board need to formally go into executive session if no one else is there? So it's just the 3 board members and the manager, but we do need to talk about a collection issue. The answer is yes. You need to formally go into executive session, even if no one's there. The law doesn't differentiate. It doesn't say you only do it if there's more than X number of people there. And what's really strange, and we sometimes get a little sloppy at this, but the meeting minutes are always right. When you come out of executive session, what happens is the president or the community manager will say, okay, and turn to everyone who's not there. Okay, we're now out of executive session. We talked about a collections issue. So we do recommend that you practice the procedure so that when you actually do have folks there, you handle it properly. And then finally, the question is, when do you hold an executive session? And if we were live and I could see you holding up your hands, I would ask, and we'd have some of you hold your hands up that says at the beginning, some hold it up at the end, and maybe a few of you actually hold it in the middle of the meeting. There's actually great logic for every one of them, and one community shouldn't just be fixated on one. So if you're holding a DR hearing, for example, we typically would want to hold that at the beginning of the meeting. If your meeting normally starts at 7 and everyone's used to a 7 o'clock meeting, hold your DR hearing at 6:30 or 6:45. So the person coming in can come in, get their business taken care of, and go home because they don't really want to stay for the whole meeting. If you have a situation where you want to deal with all these collection issues and deed restriction issues, well, let's maybe hold it at the end of the meeting. So homeowners come in at the beginning, they get to do their open forum part, you cover all the business they want to see, and then they can go home before you spend 30 minutes or 45 minutes or an hour on all this other stuff. So it's really wherever it fits best for the circumstance of that executive session. Kim, I think you have another question for us.
Yes, Ralph, I do. And I'm going to give you the questions, the rest of the questions. If you would repeat the question so that everyone can hear it again before you answer it. We have a question tonight coming from Norm at Oakcrest, and he wants to know, does the law require people to provide their email address to us?
The question was, does the law require people to disclose their email address to us? Sadly, no. That was easy. Any other questions?
None at this time.
All right, then let's go ahead and move on to the last segment regarding the laws. And this is elections and voting. There's a lot of things here, but we'll actually be going through them pretty quickly. The first item is this. Owners must be given an opportunity to get their name on the ballot. And so the law says that at least 10 days before we're going to send out the official meeting announcement and the ballot, we must let all owners know that they have an opportunity to self-nominate. There's two ways of doing that. We can mail it, or we can do the same thing like we do on a meeting announcement, which is to put it on the website and e-blast. We typically prefer to send out a postcard to everyone, simply because that will get to 100% of the owners and not just the maybe 50% or 60% that we have email addresses for. But that's really up to the board. We can also take nominations from the floor. Unfortunately, if you take nominations from the floor, that person nominated is at a disadvantage because their name isn't on the ballot. And all of the people who have voted by absentee voting, by online, they wouldn't have had an opportunity to vote for someone who was nominated from the floor. However, nominations from the floor are critical if we don't have enough names to fill all the slots. So if we come into a meeting with 2 openings and we only have 1 name on the ballot, you'll normally see your community manager begging people in the audience to please, won't you serve your community? It's so easy. I'll get to why in a little bit. So a nominations postcard that we typically send out is shown right here. And it simply says, if you're interested in serving on the board of directors, register by a particular date. You go to our website, put your name, address in, and you put a little bio in there, a little candidate speech, if you will, that we would then mail with the ballot so people who don't know you will know a little bit about you. So that's nominations. The next area, and this is one that definitely conflicts with most bylaws that are older than literally 5 years old, and that is in effective January 1st, 2012, the law says that any owner may run and serve on the board. Most older bylaws, indicate that you must be current on your assessments. You must, whatever, various qualifications that were in the bylaws. Nope, under state law, anyone may run. They may owe the association $1,000. They may be suing the association. They may live in another country. There is no qualification for board members. Now, the law does only address owners. So if you're not an owner, you have no right to serve on the board under the law. That doesn't mean that an association wouldn't want to welcome a tenant, a longtime tenant who just wants to serve the community. However, since the law doesn't address it, if a community wanted to amend their bylaws to say no tenants, that would be legal. Probably not a great idea, but it would be legal. One other thing that was placed in the law is an automatic removal of a person from the board of directors. The board doesn't need to make a motion. This is automatic under the law. A person is removed from the board of directors automatically and immediately if the association is given or provided a written document from a law enforcement agency that indicates that this person has been convicted of a felony or a crime of moral turpitude within the last 20 years. Moral turpitude, that doesn't have anything to do with moral issues or morality. It has to do with fraud, deceit, dishonesty, all of those things you don't want on someone on the board handling the association's money. So if someone has been convicted, that person is automatically removed from the board until their conviction is 20 years old, and then they could run for the board again. We've had some situations like that. In one particular community, a person was attempting to run from the board of for the board of directors, had submitted their nomination, self-nomination. It was well known in the community that this person was a convicted murderer who was out. And that was a situation where the community manager was not comfortable telling that person directly that they could not be on the ballot. And in some cases, you do want to use the association's attorney to break the bad news to a convicted murderer. So, enough for that particular story. Let's go on to the next item. This is meeting notice. We're going to touch on this as we did for a board meeting, but this is for member meetings. This is meetings where the owners get together to elect the board of directors or vote on other topics that they're authorized to vote on. No matter what your documents say, under the law, the meeting notice is 10 to 60 days in advance of the meeting is when the notice must go out. That's all there is for that particular topic. Let's now get on to voting rights. This is another thing that your bylaws, if they're older than about 5 years old, this overrides what your bylaws say. And it says all owners may vote, period. You cannot disqualify someone from voting because they haven't paid their assessment or anything else like that. That was a common thing that was in various bylaws or, in some cases, deed restrictions. Every owner has the right to vote. And if you think about that, that's what lawmakers are used to. You don't have to be current on your property taxes in order to vote in a governmental election. And so this kind of brings you more towards what the lawmakers are used to. Anyone can vote. However, we can disqualify a vote for a valid reason. So for example, if we have a ballot they need to sign and they don't sign it, if they are voting electronically and we cannot verify their identity through our PIN number, which I'll talk about in just a second, we can disqualify that. If we have 3 candidates for 2 positions and they put check marks next to all 3 of them, we have no idea who they're not voting for out of those 3. So there are reasons we can disqualify a vote, but we can't prevent any owner from voting. In fact, we want to encourage people to vote. So how can they vote? A great thing that was included in the law, starting in 2012, was creating these 4 voting methods. C.I.A. Services has actually been using these 4 voting methods since the year 2000 when we first opened up our website with its secure online voting. And we had a way of doing it, and we're pleased that the law caught up with us. But the 4 methods are: you can vote in person at the meeting, which is what we really like people to do. You can vote by absentee ballot, so you can mail it in. Great convenience for all of our busy homeowners. You can vote electronically. That's our online voting. So it's like an absentee ballot. You just go to your computer instead of putting a stamp on it to send it back. Or you can vote by providing a written proxy to another person to attend the meeting on your behalf and vote for you. Up until this law was passed, everyone in the industry misused the word proxy. Proxy specifically means you're giving someone your right. People would use the word proxy in place of absentee ballot. They'd go around walking to people's homes and say, sign this and vote for me. Well, if they were signing and voting, that was really an absentee ballot. They weren't giving their right to that person at the door to vote however they wanted to. Now, one of the things in the law says that if you're not at the meeting and the proposal changes, let's say you're voting on whether to paint the clubhouse blue or red, and someone at the meeting says, you know, why are we fighting over this? Let's do purple. And you voted for red or blue, you did not have the opportunity to vote for purple, so the law says that your ballot gets thrown out. The law also says very nicely that if you attend the meeting, whatever you sent in advance doesn't count. You get to change your vote right there at the meeting. So when we have an annual meeting and people sign in, on our little registration sheet, we know if someone is voted in advance. If someone is voted in advance, 100% of the time, we hand them back their ballot, staple to it a ballot for the meeting, and they get to vote again. And we only count the one from the meeting, because we always want to give people the opportunity, if they choose to change their vote. There's a few things that are out here regarding the other voting methods, but I want to ask him to ask me a question on this topic.
All right, Ralph, I have a couple of questions. I'm going to do one right now from Brian, who's coming to us from Custom Management. And he wants to know, can a member be removed for missing meetings?
Oh, great question. Brian, thank you for joining. Brian's got a very well-established management company in Humble, right down the street from our North office. So Brian, thank you so much for joining. The question is, can a member be removed? And here we're talking about I'm assuming a member of the board of directors. Can a member of the board of directors be removed from the board for non-attendance? The state law actually doesn't address that. And so that goes back to specifically what your bylaws say. It's a common paragraph in bylaws. There are two that are common. One typically says that an officer can be removed at any time by the other board members. So if you have a secretary, for any reason at all, the other board members can say, you're no longer the secretary. Some people sometimes confuse that when they read that an officer can be removed. Brian knows this, but some of the rest of you may not. They sometimes confuse that with removing them from the board of directors. That's not what it is. It says we're just stripping you of your title of vice president because you've done too much, and vice presidents don't do anything. I'm kidding. But you can remove them from the office. The question is, can you remove a board member from the board itself? Some bylaws have a phrase in there or a paragraph in there that talks about you can remove a board member for missing, the typical phrasing is 3 consecutive meetings, regular meetings of the board. If your bylaws have that and a board member misses 3, even if they're excused, even if they're in the hospital, you could be heartless, so to speak, then the board of directors, if that's in your bylaws, has the right to do that. If you don't have that in there and someone's not participating, no one can remove that board member except the board member themselves by resigning or dying, or the members through an impeachment process that's typically in the bylaws. So how do you handle that in practice? The answer is, if someone's not participating, the best thing to do is to approach them and say, as nicely as you can, would you mind getting off the board? Because we have someone who would like to join the board. A whole other question, which I'm going to address in a moment, is how would you fill that position? What other questions might you have? Thank you, Brian.
Ralph, Donna with Flying L would like to know, can owners of abated lots vote?
Wow, interesting. Thank you, Donna. I don't know what abated lots means, but let me suggest maybe what you're asking about. There may be some lots which are exempt from assessments, for example, because that they're a consolidated lot because of something else that the developer put in there. The answer to that is absolutely in your governing documents. It's going to indicate either that voting and assessments go together or they're two separate issues. So in that particular case, you'd have to look at your governing documents to indicate that. And I've actually seen it both ways. Thank you. What other questions? Good questions.
We have a question coming from Carlos Hernandez. He wants to know, can a homeowner serve on the board even if they don't live in the community, but they still own their home, but they just rent it out?
Oh, good question. So can can people who don't live on the community serve on the board? I actually skipped over that. That was a few slides ago where we were talking about qualifications. And I skipped over it because the law is really squirrely in the way it's written. It basically says that you can, if you amend your bylaws, you can say that all board members must live in the community, except the law says you must allow at least one to not live in the community, which is really squirrely because it doesn't indicate that you can, how many you must allow on the board, and what if someone moves out, are they immediately kicked off? So that's actually a little bit of a strange answer as to what the law says. So, let me go ahead and finish up on the voting. Ballots, the law says that ballots must be generally in writing and signed by the owner. The law does say that if you have a mechanism for verifying ownership and preventing duplication, that you don't have to sign them. When this part was put in 2015, we changed our procedures internally. Up until then, every ballot that we'd bring to a meeting had a line where you must sign that line or we would disqualify it because that's what the law said. When the law changed, we removed the signature line from the ballots voted at the meeting because we have a mechanism for preventing duplicates. You register when you come in, we check you off, you get a ballot. We know that your wife can't come in later and get another ballot, or you can't grab a stack of ballots from the table. So we're all set there. Another part of the law is that if you have an uncontested election, we have two people running for two positions, you don't have to actually do the paperwork and pick up the ballots. You can ask if there's a motion from the floor to accept the slate by acclamation. We say aye. Those two are then elected without having to physically pick up the ballots. In terms of security, the law is very clear that the actual votes of any individual owner may not be disclosed to anyone, period. And the people who are counting, and there's this cute little graphic with all these overly attractive people in there. This cute little graphic that basically says that vote tabulators may not be related in blood, by blood or marriage, any closer than the third degree. So in that particular graphic, you'd have to get to Mom Jan, who's the fourth degree away from the candidate. The law, and I'm going to skip these next two slides, but briefly, the law has something in place such that if there is someone who contests the election and requests a recount, there's a process under the law. Procedure they need to go through, they need to pay for the cost of the recount, and then the recount is, the results are disclosed to them. The interesting part is if the results change due to the recount, then the association must reimburse that person for the cost. Results change doesn't mean that instead of winning by 10 votes, they won by 8 votes. It means changing the result of the election. That, oops, we counted wrong and that person should have been elected instead of that person. Recounts are extremely, extremely unusual. We do a triple count at our annual meetings to make sure that everything is accurate when we leave the meeting. And then appointments very quickly. If there is a vacancy on the board because someone has resigned, died, or something else, been disqualified due to a conviction, then the board of directors may appoint someone into that vacancy. That appointment lasts until the end of the term. They would make that appointment, as you heard earlier, in an announced meeting. If, however, a board position expires, so we go into an annual meeting, this term is up, and there's no one who volunteers to fill in that position, the board has zero authority to appoint into an expired position. The only way to fill that expired position is by holding another election, which for most associations is going to be a little bit expensive. Failure to hold an annual meeting is something that doesn't apply to associations. It has nothing to do with not meeting quorum. It's all about a situation, a rare situation, where every single board member has resigned, moved away, or died, and there is no board. There's a procedure under the law to actually get a new board in place. Under the practical issues, a couple things. Must an association do background checks? Now that's kind of interesting. So all of a sudden we've got background checks going on all the candidates to see if we have anyone who's been convicted of a felony or a crime of moral turpitude. Absolutely no requirement. And we really don't suggest that we get into a situation where candidates are doing it against their competitors. But we have seen that, so it does happen. Must an association offer 4 methods of voting? No, only 2 are required by law, but we always suggest that all 4 be used. Why not? It gives people options. Why is it extremely important to fill all expiring positions? We just answered that. Because if you don't, you have to hold a special election, and that's expensive and time consuming. We already answered the last one. How can a board member be removed from the board? So, good, thank you. I think that was Carlos who asked that question. Good job. Well, we just have 5 minutes left, so I'm going a little quick now because I want to handle what's coming up in the 85th session. I already mentioned that the legislature meets for 145 days. They started on January 10th of this year, and they'll finish up on May 29th. The deadline for normal filings is on March 10th, so all the bills that should be filed by then. Only what are described as emergency bills can be filed after that. So we're just 10 days away from knowing what the session's going to look like for associations. There are just a couple here I want to highlight. House Bill 207. House Bill 207 deals with a safe zone for relating to child predators, sex offenders, and things like that. What's interesting about this, there are safe zones right now around churches and schools and things of that sort. This law would expand it to generically playgrounds, not public playgrounds, but any playgrounds. And the zone could be, right now it's being proposed as 1,000 feet, but who knows what it would end up being like. So if you have a playground in your community, if this law passed, it effectively would eliminate the ability for a sex offender to be in the community. Because of that part of it, there's probably going to be some opposition because it's overly broad. Who knows? But it's interesting how it may affect and help associations. House Bill 755. This is something that affects very few associations, mostly master planned associations. So I'll skip it over. You can read it for yourselves. House Bill 923 is a really good bill in concept because this has all to do with fines. Not all associations have the ability to implement fines, but if you do, what this law says is the fines must be reasonable. They must be reasonable based on 3 factors: the nature of the violation, is it really bad or is it not so bad? The frequency of the violation, is this something that infrequently happens or is continuing? And the effect on the subdivision. That all makes sense, that you would want the magnitude of the fine, the dollar amounts of the fine to be reasonable. The problem is, it just makes it so much harder to actually write a policy for fining. How you would define what is reasonable. And it leaves the decision on any particular fine up to the board of directors who's in place at that particular time. So a great concept, but it'll be challenged as to how it's actually implemented. So I see that as a thumbs up with wondering. The next one, which is House Bill 522, this is one that I see as a very difficult law. In 2011, a law was passed that basically protected an owner for putting a mezuzah, which is in the Jewish faith. It's a very small item that's about as big as I'm illustrating right here that goes on the doorway of the entry to your home. And in condominiums, they were saying, hey, that's common area, you can't do that. But it was violating their tenet of faith. So a law was passed to protect that. This law is saying that any religious item that owner is sincerely motivated by their faith is protected. It doesn't talk about size, it doesn't talk about placement, it doesn't talk about, conventional religions. So someone who is a Wiccan who wants to, and I'm not good at these, some of these religions, but hang a goat with its neck slit that the blood's dripping out, and they truly believe in it in their front yard, conceivably could be protected by this. A 40-foot cross that's lit up at night. So this, to me, seems to be a law that's been introduced to solve a problem that maybe hasn't existed. The last one I want to touch on has a number of things on it, but I really want to get to the last page of this. There are 6 parts of this particular bill. That's House Bill 1341 out of a legislature who's not in a very big county, Hidalgo County. But the last part of it, if you'll just look at the last 2 on this page, first of all, it says that if an association violates Chapter 209, Chapter 209 is the one that covers all these procedures I've talked about. It says that a county attorney, a state attorney general, a district attorney may all prosecute the association, all have the authority to prosecute the association for a violation. So if we don't post a meeting notice that we should have, all of a sudden we might have the state attorney general prosecuting an association for something like that. I could very much see that as a situation where a disaffected homeowner would use the resources of the state to pound down an association. So that's real concern. The worst one is the last provision, though. We've talked about owners having a right to attend board meetings, and we want to welcome them there. This law would say that not only do they have the right to attend, and they have the right to speak, but they have a right, everyone who's there has a right, uninterrupted by the board, to speak for at least 30 minutes at every board meeting. Wow. So, with all that said, I wanted to, first of all, point out the other seminars that are coming up. I'm just going to answer a few questions because I want to respect your right. And by the way, you'd be embarrassed if we were in a meeting to just walk out, but here you can just walk to the kitchen, go to the bathroom, whatever you want. So I will stay here and answer a couple more questions. And what do we have, Kim?
Ralph Penny at Flying L would like to know, a homeowner has for years repeatedly brought an issue to the board in public forum requesting that the POA pay for all or part of a drainage issue on their particular property. Several boards have voted no to their request. After the last election, the homeowners requested an executive session to present their case to the new board members. Can the board refuse this misuse of an executive session, and can the board refuse to let the homeowner continue to bring the issue before the board?
Wow, a lot of good things in that particular question. Let me touch on all of them briefly. So, starting from the end, one of the questions, can the board refuse to grant an owner an executive session? The law is specific about where an owner has a right to a hearing. And those have to do with compliance, enforcement, collections issues. So in those situations, not this one, absolutely the owner has that right. If an owner wants to talk to an owner in executive session, there's no obligation under the law for the owner for the association to grant that, unless it's those topics I talked about. But generally, you would want to. And so the first time this person brought it up, great. Meet with the person, set a time limit on the executive session, hear it. If they want to bring it up again, the answer would be, please tell us what's different, and if there is some new information for us to consider, we'd be happy to have an executive session. But to answer your question directly, there's no obligation under the law to just grant executive sessions because someone has asked for it and it's not one of those protected categories. Very briefly, if we're talking about what you indicated, the homeowner in that case wants the association to spend money to solve a problem on their private land, we really need to examine what that situation is. The association in general should never be spending money on private land. However, if the association is causing the problem, then the association has some obligation to remediate the problem. If the problem existed before the association, in this case it's a natural drainage way, and the owner just doesn't like the fact that water comes across their property, the association has no obligation there. Thank you. What's another question?
Donna W. out at Flying L has just a random question that she wanted me to ask at the end. She says, if a homeowner writes a community newsletter, meaning a newsletter out in the town, the city, not a POA newsletter, and is later appointed to an open board position, must that community newsletter now be subject to editorial review by board members because the newsletter writer is now on the board?
Cool question. It's surprising how often those communication issues come up, especially with all of the social media options that are available and platforms that are available to folks. So everything from Nextdoor to Yahoo groups to all those other ways that people can communicate occur. And even newspapers or blogs or whatever might be the case here. The association cannot control free speech. The association cannot control what people are saying. The best way to counter that stuff is not to, in my opinion at least, is not to get onto those blogs and start a fight in the blogosphere, but to put out the information that the association wants, to communicate with its owners, to get the message out through newsletters, through website postings, through e-blasts and things of that sort. Does a person need to stop their free speech rights because they get on a board? No. Is it appropriate for someone who is a member of the board of directors to be working contrary to the board of directors? Absolutely not, and that's where ethics come in. Thank you for that question. And we have one more or two more?
Actually, I have two more.
Okay, two more. Thank you.
Denise Reyes would like to know, if a homeowner continuously reschedules their hearing, at what point can the board deny their hearing request and proceed with deed restriction enforcement?
Well, that is a great question because we sometimes actually run into this. And so I'm going to give you the hard legal answer to this. The law says that an owner must make a written request for a hearing. Great. And that the association within 10 days must set that hearing to occur within 30 days, 30 additional days. And that either party can request an extension of, I believe it's 10 days. So basically you have a 40-day window. Neither of the parties need to agree to extend that beyond that 40-day window. And so what we recommend in a situation like that, the hard case, normally you want to accommodate. You want to come up with a date where you can get together because hearings are how you resolve problems. Normally you want to. But if there is a situation where the association is being played, so to speak, and the owner truly is not interested in resolving it, they're truly interested in just deferring action, then what the association can do is state it will be in this 30-day window. They say we need more time. Okay, we'll give you 10 more days. And then you hold the hearing at that time, even if the person says they can't come. You have set the date, you have accommodated the extension, you hold the hearing, you put it in the meeting minutes that we held the hearing, the owner did not appear, we concluded the hearing, and we're now out of executive session. So that's a hard approach to it that you only want to use if it's the last resort. Good question.
We have
We
one.
need to hire her as a community manager.
You know, I think we already did.
Oh, okay.
Great
Thanks,
job,
Denise.
Denise. Linda Schaefer over at C.I.A.
Yes.
would
another-
like to know, how do you feel an association should or should not participate in Facebook or any other social media platforms like Nextdoor?
Thank you, Linda, and thank you and the others from CKM Management up in Tomball, another great management company, for that question. That is, I briefly answered it before, but it's a very tough question because anyone can create those platforms. And when used well, those are great platforms. Having a Facebook page or a Nextdoor page or a Yahoo group that is used to augment what the association is doing. It's the site where maybe a lot of the social things are happening. It's the site where you can get an immediate communication out that there is a water main break, so get home and secure your house. So there are a lot of very positive things about those alternative social platforms. The problem occurs when those platforms go awry and the members of that platform generally try to rein it in because they don't want to have all this negativity, but not always. From a management company standpoint, it's very difficult, and it's the policy at C.I.A. Services that we don't get involved with those, that we don't monitor those sites, that we don't give them the legitimacy of responding to complaints. Sometimes board members are involved with them, and sometimes board members will respond, although, again, it can go off in the wrong direction. So that's our answer is they can be a tremendous augment to a community, but unfortunately sometimes things go bad. And that is the end of the seminar. Thank all of you who have participated, all of you who've stayed till the end and listened to what we've had to say. We do have, as the slide you're currently seeing or last saw, shows that we have more seminars coming up. We're going to actually send all of you, everyone who registered, a quick survey that you'll receive either tonight or tomorrow in an email. I believe it's a SurveyMonkey survey. Just a few questions. We'd like your feedback. This was our first time. We had some audio issues that we've learned about. We want to know if you like this, if this is worthwhile to you, both if the topic was useful, but more if the format of what we did was helpful to you. So if you would, please give us the goods and the bads. Please reply. In about a week, our intention is, if it's overall you felt that this was useful, we're going to go ahead and release the schedule for the rest of the year. So all of the seminars will be coming up. We've got a board member orientation, which will be coming up here shortly. collections and financials, deed restriction management, and architectural control will all be coming up. So please give us your feedback. Thank you so much for coming, and good night.